Thank you for all of you for making it on a freezing rain day. I know this seems like the best thing to do, get together and hear very informative things from our presenter today, Jawahar. It's 7:03, and Kaushalya, if you want to do a quick introduction to Jawahar, we can take it from there.
Yeah, sure. I'd like to introduce Jawahar from Financial Miles. He is a licensed investment agent who focuses on helping individuals and build families to protect what they have built and plan confidently for the future. For many of us in our community, planning for our family's future and next generation is very important. So today, Jawahar will share some helpful insights on simplifying financial decisions, understanding estate and legacy planning, and structuring wealth in a way that supports the people who matter most of us. I'm sure this session will be very valuable for all of us. So thank you, Jawahar, for this wonderful opportunity to advise our community. So now I'll over it to you, Jawahar, sir. Thank you.
Thank you so much for that warm welcome on a cold day, and couldn't have asked anything better than this. So my whole presentation would be pretty much in English, but since we are all from the Kannada community, can't I can't skip to start with Kannada. So I'll just say a few things like ನಮಸ್ಕಾರ ಎಲ್ಲರಿಗೂ ತುಂಬಾ ಖುಷಿ ಆಗ್ತಾ ಇದೆ ಇವತ್ತು ನಿಮ್ಮೊಟ್ಟಿಗೆ ಇಲ್ಲಿರೋದಕ್ಕೆ. I will get started with my presentation. Thanks for joining. Get going. Just to confirm, logistics side, everyone is able to see my screen and hear me well?
Yeah. Yeah.
Perfect. Thank you. Yeah. So we are talking about today estate planning. Of course, I am very proud and happy to represent my company, Financial Miles, in order to deliver an exclusive session for Kannada Sangha Ottawa community. So here are my some credentials. My name is Jawahar. I'm a licensed investment and insurance agent, as Kaushalya mentioned, and I represent my agency, that is Card Financial. So with this very brief background, I want to get into the meat and would like to keep most of the time for question and answers, so that's where exactly we can do the justice for this knowledge, plus some of the queries that you might have carried all this long to be answered. A good estate plan isn't just about how much you live, actually, but it's more about how peacefully it is being done when you're not there. So we hear a lot of court cases, especially in Canada, with a lot of Canadians walking up to the court and then fighting it out for their rights or possessions. So we need to make sure that our estate plan has lesser problems when we actually not there, so which is very critical. So my whole target today is to bring in some awareness or tips and suggestions from my side, what we can do in order to help plan our own estate. With that background, I would like to get started with the agenda. Pretty much a slide to know what would be covered. However, before we get started with the actual presentation, I wanted to do a quick quiz. So I'm just going to stop my screen share or the presentation mode for a moment, send you guys a link. Take a minute or two, it's a timed out quiz, to post your answers, and thereby we know what we are going to learn. So the link is posted in the chat. Feel free to click and start providing your answers. Don't worry about right or wrong answers, and don't Google for the questions, because the time limit is very less, and you can happily come back whether it is right or wrong. I Hope the link is working well. If someone can confirm, that will be really helpful.
Yeah, it's working.
Perfect. Thanks. It's now 7:08. I would move on to the next slide while even you complete the quiz at your own time at 7:09, just in interest of time. But I got it. I've started getting some responses, which is really good news. So, as I said, I would like to move forward. If you're not completed, you can take your time. That's fine. But don't worry about anything that I've written on the bottom. Just to keep it light, I thought of putting those sentences here. Yes. So we talk about estate planning pretty much every single time we meet up concerning what would happen when we are not there. But there are a few basics that we all need to understand. What is estate? What is testate? What is intestate? Estate is generally all your assets, debts, and property after you're not there is what we call it as estate. Even if you have a will or not, it is still an estate. With the will, when you have a will, it is called as testate. So that executor, whoever is appointed as an executor under the will be able to follow the instructions to do the needful, what you actually want to do after you're not there. However, when someone dies without a will, it is called as intestate, which is a very concerning state because court comes into picture and a legal process called as probate will get kick-started. The sad part of the probate in this country is pretty time-consuming, and when court comes into picture, in order to just assign an executor nominated by the court for the probate process is minimum 5 to 6 months just to get appointed. From there onwards, if there is no will, then the executor will take his own time to verify all the documents, gets some of those from the institutions. And then if he has to do justice, it takes at least a couple of months after being appointed. So basically, we're looking at about 1.5 to 2 years of time if you don't have a will, which is called as intestate. Why we have to have our estate planning is something that we will get into, but when we have to start estate planning is most of the time we have as a question. A simple family, husband, wife, and kid, who doesn't have a car, doesn't have a home, doesn't own a home, but just with having a bank account also need to have their estate plan in place, because even the bank account, for example, would get frozen up if there is no direction of that account what to be done if the person passes away in case of individual accounts, which I will get into in detail, which might be of little bit of interest because I'm trying to target those daily aspects of work or accounts or registered accounts that we deal, which will help us to be prepared for estate planning. Basically, estate planning is not about sitting down when you are at closer to the retirement. It's rather right from the beginning. Get started is what is the mantra in this. So I have listed out some of the life stages where and how the estate planning needs to get into picture. Like in early ages, we need to think about your RRSPs to have beneficiaries. Once you get married, you need to see that your RRSPs have proper assignated a spouse as a beneficiary to roll it over. Kids, we need to make sure when we have kids, we need to make sure we have guardians to take care if both husband and wife are not there together, so that we need to see we have enough life insurance to be carried over and their education plan for RESP. So I'm not going to read out all these. This is pretty much available, and I'll be happy to share my presentation so we can look at this in detail as we move forward. So, as I promised earlier, I want to take a simple example so that we know on day-to-day basis how we can start our estate planning process right from tomorrow if some of us have not done it yet. What happens to the bank account upon death? An individual bank account gets freezed in Canada when death happens. Bank seizes all the transactions, all the post-dated transactions, I mean, until the executor provides the death certificate for the probate process, which is through the court. Hence, it is my earnest recommendation, or you can take it as a bonus tip, that it is beneficial to have our accounts being opened as a joint with right of survivorship, which means as soon as a spouse A passes away, spouse B has the complete control of the account. Thereby, there is no freeze and it is free. We need to ask, we need to walk up to the bank and talk to them and then do the needful. It's with happiness that the bank would be able to do it as a joint account, and the surviving spouse can take over. And there is no stoppage of any transactions which is actually happening or post-dated ones. Yeah, and of course, don't forget to take your spouse along with you when you want to do this. I wanted to ask, can any one of you guess who might have told this statement? You can unmute and say if you're speaking aloud. No problem. So this statement was by Warren Buffett, where he says that your children are going to read will someday. It's crazy for them to read it after you are dead for the first time. You are not in position to answer all the questions. So, as I said earlier, you should have your will, which is the foundation of your estate planning. That's exactly why I wanted to get started with there. So here we come to the main part of the estate planning. What constitutes, what are the pillars of estate planning? Why we need to think about all of these aspects of estate planning? There are a couple of items which we'll go through. And of course, with this era of AI and Google, there is a lot of information available. So I am not reinventing the wheel here, to be very honest with each one of you, but I would like to bring in my expertise and point at those areas which we deal day in and day out in my business as an investment and insurance agent. So I'm not going to explain what is the will, what is an executor, and what is the uses of power of attorney and guardianship and stuff like that. But I would like to point out certain aspects of will where we have most of the time the questions like, hey, we should do an online will or a paper will which is registered with an lawyer or estate lawyer, things like that. So my preference, number one, is always to go with and work with your lawyer. And it is possible in this era to keep this will as generic as possible, even for a duration of 20 years. That's how lawyers are trained, because if you don't add a new family or make your family structure complex, unlike most of us don't do that, but I'm saying in general terms, or there are changes in the properties or businesses or you move out of provinces and stuff like that. Until then, you technically don't need an update into your notarized bills. The reason is lawyers are equipped to write the wills in a very generic way, which will be just enough for you to take it forward for a long time. And don't forget to ask lawyers when you work on your wills. If you don't have one, you should actually get started with it to see that they provide one free update after your bill has been in place. So most of the lawyers do provide that one free update, maybe 5 years down the lane or 6 years down the lane. This is just a nugget for you to know so that you can talk to the point. And coming to executors, a lot of us have executors in mind, being from our own family who stay in India. Unfortunately, executors being in India, which is our home country for most of us, is not going to help to a greater extent. The reason is the hardship of an executor to be present to deal with the probate process or legal settlements through the court when there is no will is next to, I can't just explain. So if someone is asking a question, there was a joke I was hearing the other day. I would do everything for my friend, who is my best friend, except for one thing. That one thing is not to be his executor. That's exactly how the scenarios are, because executor jobs are pretty much detailed out. The person needs to spend some time, and there is a lot of efforts that goes into it. So what is the way around? We know we have our immediate families back in India, but you can also do a joint executors being part of the will. Whereas if joint and severely is what is the term that needs to be asked to your lawyer when you sit and work on your will from the executor standpoint. What happens with that is if one person is not able to travel and be part of or physically present during the process, he or she can give a written consent to the other joint partner as an executor to do the needful in the home country. So that's exactly why that concept needs to be discussed with your lawyer. So I'm just giving you those nuggets, which would certainly help you to make your will, which is the foundation of estate planning, very effective. Power of attorney is pretty much required when you are alive and incapable of taking your decisions, be it if someone is having dementia but not loses the memory to do the needful. So power of attorney tells that person that, hey, he's or she is going to execute all the decisions on my behalf. That exactly also happens when you are critically ill to take some kind of health directives. We call it as health directive or leaving will, which will enable the person to take decisions to be operated or to do anything with you to move forward. So guardianship is also another important aspect when we have kids. I'm going to talk all the worst case scenarios today where both husband and wife are not there. Then guardianship comes into picture where we need to know under whose guidance or whose umbrella our kids are going to grow. So choosing an executor, choosing a guardian is of real importance for us to make sure that kids are in proper hands. Here, I would like to take a minute because it is most important for all of us. People might ask, hey, can I give guardianship to my grandparents back in India who can, come over, travel, and since their guardianship is mentioned in the will, can they take the possession? Many of the times it is not, because it has to still go through the court process and get the court permission. By any chance, if the kids are above 14 years, please don't forget this. If kids are above 14 years, even if you have named the guardianship in the will, court does ask the consent of the kid to see if they would like to really go back with the parents or with the grandparents or still stay back. So at that time, if they choose based on the kid's decision, court will act. So these are very important aspects that we all need to consider part of our estate planning. Of course, don't worry if any of these points are a little bit overwhelming and you want to talk in detail. I'm always here, a text or call away. I would be happy to chat even after the session or any day at a planned time at your convenience. With that, I will continue on the trusts. Many a time, trusts are in discussion when you sit down for a Friday evening or a Saturday party. Hey, would you like to set up a trust and stuff like that? But trust, to be very honest, if you work with a lawyer who is professional in the estate planning, they also will let you know that trust is only needed when you have very complex situations in life with couple of families, with couple of kids from first family, second family, and also some of the disability conditions where parents know that kids cannot take care of their businesses or their empire that they have set up because of their incapabilities or some bad habits or some kind of impacts that they can bring into the business. So what they do is they set up the trust and then they have a process under the trust to get the income or any kind of assets being given to those beneficiaries in a timely fashion or a planned fashion. So trusts help to do those things rather than completely giving away the assets or completely transfer of your death benefits to your beneficiaries. So trust, technically speaking, is not required in most of our cases unless you have complex business structures, complex families, and health conditions of your beneficiaries, which is not giving you confidence to transfer directly. Forget not, trust incurs annual charges every year. You need to pay that money to keep the trust active. It is not as simple as that we think. Otherwise, a properly structured will with a known guarantor and an executor is pretty much enough for most of the cases. Last but not least, documentation is a prime need. What documentation means is you need to keep things in order so that people know what, where, and how to access. So that is pretty much something that we can bring in a discipline to organize our documents. And of course, I'm going to talk about more about 7 and 8 as we proceed through the presentation. Yeah, I just wanted to put through these points here because will, even if you have a will, many a times estate still has to go through the probate process unless, as I told in case of the bank account example, where you have a joint ownership not being put on that, those kind of assets will still have to go through the probate. So just by having a will itself is not the solution. That's exactly where I'm sitting in front of you to let you know, in spite of having wills, in spite of having joint ownerships, what else and how other ways that you can actually secure your estate. We will get to that very soon. So many a times we all understand, on a very blank statement point, you need to talk to few lawyers to know how stressful the process is. Because if you know a lawyer who is a very good friend of yours, who is into this business, they can open up personally to you, let you know what hardship a family or an individual passes when there is no will or interstate, as we said. Let's use those terms. So basically, it's not only financial burden, but also a lot of emotional burden. And it takes a lot of time and it creates ripple effects within the family relationship. So we need to be very careful. In addition to all that, if one person, an individual dies interstate, then there is a lot of other charges that is going to come into picture. I've tried to give you an very generic amount of values, considering an 1 million estate being a pretty much normal value that we all carry today. So, there will be, on a higher view, just understand there will be legal fees, executor fees, probate costs, and estate payout timelines, as I said, is going to be unimaginable. On a lighter note, I know in the quiz we had the Ontario probate fee. Can anyone unmute and say what is the actual max number of Ontario probate fee percent?
Is it 4%?
No, the max value for probate in Ontario is 1.5%.
Okay.
So, without wasting any more time, my interesting part of the presentation is on the case studies. So, what I've done here is I've taken 3 cases from Canadian background, just to give you a feel, not from the ethnicity standpoint. Please don't get into anything of those sort. But I wanted to uh, let my members here who have joined today to know what are the hardships the family faces from those cases. And these cases are pretty much famous, so that I wanted those only cases that you can later Google and then even read through or understand, or pick up a point to talk to me. So that's exactly why these names are uh, pretty much out there in the society. So case number 1, Rob Ford, who is none other than Doug Ford's brother. He, I've put it down in a very clear and crisp way to let everyone understand in a very easy fashion what mistakes that they have done, what happened, and what could have been the solution that we could have brought in to take care of the situation. So basically, Rob, what he did is he made the current premier of Ontario as the executor, who sold the business for $1, and then he was sued by Rob's kids and wife. What could have happened is if Rob had made a provision to bypass the estate and bypass the probate, basically all the proceedings of whatever the Rob had as a death benefit or living assets, like his business, would have directly been named to the beneficiaries of his choice, which didn't happen. He just made executor as Doug. It's their internal personal thing why the other person did like that, but we are not getting there. So the lessons that we are trying to learn is we need to name beneficiary and choose the executor very carefully. Second mistake, there was no liquidity, because when the executor came into picture, he or she portrayed it in a fashion that the assets were put on fire and then they sold it for cheap. And still, if that could have been mitigated with having sec funds being part of those liquidity, because many a times when someone dies, they don't have enough cash to take care of their even immediate funeral costs, and they would have to wait until everything is settled, which is going to take time. Hence, a simple life insurance can certainly give a liquidity to those tough times. And many of the life insurance these days have those initial disbursement of funeral costs as an immediate death benefit. Say, for example, you have 1 million and then they are ready to give away 20,000 or 25,000 on immediate basis, and then the rest of the amount can be settled later. So all of those can be done through proper planning. Unfortunately, in this case study, the family fights are still happening. 5+ years, 300K worth of fees being spent by wife and kids of Rob, so which could have been totally avoided if proper planning was done. I would like to move on to the case study number two, where we have an CEO of Scholastic Publishing. Here, what happened is, this is a unique, nice story, I would like to say. I'm like to mention the story rather than going through the table, because pretty much the table is evident with the details. So give me 1 second for that small error there. So the Scholastic CEO was married, and he mutually got separated or divorced from his first wife and started an relationship with another individual later in his years. Secretly, he had made a will to be to that person who has come second in his life. So their first family didn't get anything, and to their surprise, they got to know about this, that the secret will was prepared by the CEO of Scholastic. I'm not able to recollect his name, but this gentleman did that activity of making it secret and then executing it, which they got to know at the funeral by their first family and kids. However, very interesting aspect here is during his last days, which was later learned in the process of everything, the legal cases, that this gentleman had made a mind to part ways from the person who he was in relationship with. He was ready to part ways and then reconcile back with his first wife, and then do the needful. Unfortunately, he was mentally prepared, but the only mistake or simple mistake that he didn't do was he didn't modify his will. Thereby, he can't do anything, and court is holding accountable for the person who is on the will rather than his wish. Hence, we need to make sure the lessons learned in this particular case study is whenever there is a bigger life event or a bigger business or bigger number of properties getting increased, you add kids in your family, please don't forget to update your will. And of course, there are many ways that wills can be kept in generic and still be updated. That's the skill of an estate lawyer when you work with them to create your will. Or if you have already one, give a thought, go back and read through and then see what needs to be updated if life changes has happened. So that's the study part of in this case. I have another very interesting case here, which is again a kind of a story. We all like stories, so I would like to go with that. So Diane Taylor from Halifax, she was happily married to the person, her spouse, and he happened to be working. You can certainly get more details in online, but I'm just giving it a grasp of the case study here. He was a manager at a bank, and they had everything set except for one thing, that the designation on the RRSP was initially set as his mother, because this gentleman, being in the bank, was very prudent enough to invest on regular basis when he started his career right from young age. So he had set up an account in which he had made his mother as a beneficiary and had not bothered to change, or might have got forgotten about it. So here comes the situation. The husband is no more, and Diane Taylor happens to know that the beneficiary is her mother-in-law. In this case, she cannot have any right to defend herself to get the beneficiary amount of RRSP as a spousal rollover, which did not happen initially because mother-in-law was pretty much adamant to say that, hey, it is my son who might have thought about leaving behind some of his assets to me, so I'm in no position to give it back to you. However, later, with some reconciliation happening, what happened is she gave a written consent that the beneficiary can be changed. I'm not interested. So some of the legal aspects came into picture where mother-in-law had to give away her beneficiary rights to Diane Taylor at one condition. Mother-in-law did ask for a check of 350K for half of the money because uh, she wanted some amount back from this. She treated it as a business deal. The reason why I'm insisting this point here is Diane was in die-hard situation to arrange that 350K or 400K, whatever that was provided to her mother-in-law, which was a cash sitting from her husband's death benefit, which could have been very much useful for her own life going forward because the gentleman was 46 years old when he died, and I'm sure the kid would have been 13 years and was a teen, need a lot of funds towards her education. I don't know if Diane was working, had a career. So there was a lot of ifs and buts. So hence, taking away 350K from the cash as a death benefit from the husband's life insurance and giving to mother-in-law uh, probably have solved the situation, but it was not the ideal case. Hence, friends, I only honestly request each one of us to review our beneficiaries on our registered accounts and non-registered accounts, which is very important. And only an advisor can keep a track of that and or advise with any life situations that is going to change. So it is if you're working with an advisor, it may not be me, but whoever it is, you need to be in close touch to keep them aware of the life changes and then see that you keep updating because changing beneficiary on those products are very easy, but handling those the costly effects of not having a required beneficiary on your account is really, really costly on a long-term basis. Yes, this is another important aspects which most of us have as an account is TFSA. I wanted to bring in a case where it's a kind of tricky case. I touch wood, nothing should happen like this to any one of us or anywhere, but don't know, life happens. So the scenario is husband and wife have their own TFSAs named each other as successor annuitants. Can someone unmute and tell me what is the difference between a successor annuitant and a beneficiary?
Maybe successor in case of couples, it's if husband dies, the wife. Beneficiary is whoever is in the will.
I can give it a try.
Or is that a successor? Sorry, go ahead then.
Successor annuitant would retain the TFSA character, whereas beneficiary, it'll be paid out to the named beneficiary, but it no longer will remain a TFSA. It won't roll over. It's only a spouse that can be named as a successor.
No, rightly answered. Bhushan, you had to say something.
I thought successor, as the name goes, it's the kids, and the beneficiary could be anybody adult.
Actually, the first two answers were pretty much on target, where successor annuitants are only spouse. It can only be spouse, but no one else other than that. Because as soon as an individual passes away, the surviving spouse, irrespective of the TFSA contribution limit, it is completely rolled over. So that's how super beneficial the successor annuitant designation is. So my small homework to each one of you who are here, Deepak, can you just tell me how many of us are here right now in the middle of the session?
We have 18 of us, and we're getting close to time, Jawahar. It's 7:42.
Right.
So to slowly wrap that up.
Yeah. So what I would say is let all of us take a quick look at the successor intents on our TFSA, which is very, very important. And some of the bigger challenges in our estate planning can be taken care by sec funds, which bypasses probate. It is directly paid to the beneficiary. There is a reset options, there's a creditor protection, there's a lot of benefits involved in sec funds when you properly plan under your estate. So if you have any questions related to this, yes, you can feel free to ask or talk to me. Yeah, as I rightly said, this is more of an information slide where the probate fees are listed with the slabs in place. And of course, the max limit is 1.5%, not 4%. There is a concept of estate bonds, where estate bonds do help to take care of your needs of immediate cash requirements. And I have given a flavor of how estate bonds are different between RRSPs and TFSA. So ideally, if you have all the three, it is the ideal situation. But if not, the estate bond is one of the most important and easiest way that we can create so that the death benefit is paid out to your beneficiaries directly rather than to the estate itself. With that, I wanted to wrap up this session. I was pretty much on time, Deepa. And also I would like to bring in, as mentioned, I am not only part of the estate planning process, but I'm not a legal consultant to do any of the wills or executor. It is solely with the estate lawyers. However, we act as a backbone support of naming the beneficiary, seeing that we bypass the estate and the probate so that the beneficiaries don't have any issues. So we can do that. In addition to that, these are some of the services and solutions that I provide from Financial Miles in terms of life insurance, critical illness, disability, TFSAs, RSPs, RESP, and of course, travel insurance and registered investments, RSP loans, and estate planning. What I also bring into the table is these certifications, be it LLQP, CFP, CLU, and CPA. Of course, I'm not all four, I'm one of them, but we have a very active, technically engaged team. So we are more focused on technical delivery of the financial planning and investment planning or insurance planning rather than any other side of the business. So we have pretty much a good group of people to work on special cases if we need to put our brains to help out our clients. There are a lot of resources I have in place to give away. My request would be to just leave your email address in the chat so that I can have it and send it out your way. And these are the list of resources that you will certainly receive from my side, and your emails will not be used for any marketing purposes. So what next? That's most important. I will wrap up within a minute, Deepa. I have created a specific and exclusive link for our KST community group to book the slots, because I'm going to be in person available a day earlier and a day after our Ugadi, before and after. And these are some of the slots that I'm available for. If someone wants to talk to me in person to catch up and discuss some of their plans, I'm pretty much there. So wanted to let you know these links will be shared with the members. Yeah, with that 35 minutes of my talking, I have some of the same questions posted again. You will feel confident to answer many of them right now. And I would like to send it out so that you can redo it. In the meantime, what I wanted to mention is, let me first put it in the chat. We'll take up some questions for sure right now. This is the post-session quiz link. I am going back to my screen sharing here so that we'll take up some questions, and no score limits. You will get the resources if you're just here with the email address being posted. With that, I wanted to thank each one of you who have taken your time on middle of the week, that's Wednesday, to stay with me, giving your all attention and ears to listen to my details, which I tried to concise within a short period of 35 to 40 minutes because this topic is pretty vast and it's not a justice to do within 40 minutes, which I know and each one of us know, but still I want to respect your time. So thank you so much for being part of this session and journey so far. Here are some of the social links that you can scan or join. These links also will be circulated. You don't have to worry about it, but now with this, we can open up for any questions, Deepa and the community team.
Yeah, I think anybody who has any questions, this was really informative, Jawahar, and I think the quiz also makes us figure out what are the things that we can learn, right? So thank you. Thank you for putting all of this together. Very informative, very good session. I think anybody, if you have questions, you can unmute yourself or raise your hand, and then Jawahar can take the questions.
Yeah, Jawahar, thank you. It's Sudhi here, and thank you so much for the session. I have one question. If there is a no will in place, example in a couple scenario, a husband and a wife, if husband passes away, so will it has to go through probate for the wife to get the proceedings, or it is automatic?
That's a very good question. Let us add some frills to that particular condition where or a scenario. Husband passes away, they don't have a will. Wife will get the primary residence rollover for free, which is not a problem. And if their situations or investments are not that complex, and if they have named each other as a beneficiaries, then most of the problems are solved, to be honest with you. Okay. But if the designations of beneficiary is not done, the bank accounts are not joined, and there are other complications that comes into picture, which is case to case, then yes, it has to go through the process of settling down with legal proceedings.
So in a simple scenario, this should be, I mean, it should be straightforward. It should be
Absolutely simple scenarios. It is
but
straightforward.
it still needs a court intervention, or it just happens automatically.
I don't think so. There is a court intervention here. The reason is if there is no will, the court intervention will get delayed or complex when some of the things will go and sit under the estate.
Mm-hmm.
If sitting under the estate, the person who is going to execute that estate doesn't know anything about your life. So he takes time to dig in a lot of information before he settles that. So if you have bypassed your estate proceedings by having the benefits being given to the beneficiary directly and house being put on to roll over to your spouse, as I said, it's situation to situation. So in a simpler situation, it should be fine. But we never know what the family is going through, so we need to know a lot of details before we actually answer that.
Okay, sure. I have one other question. So, is both will and power of attorney is needed, or just will is enough? Power of attorney is mostly when you are not in a mind. I mean, when you're not in a position to make the decision, right? But can we have
Yes.
will first and subsequently we can have power of attorney later, or it has to be together?
I will give you my expert tip here because when you go to a lawyer and sit down, it's better to get all the 6 documents done together. Okay. Don't delay the POA, what we call POA is power of attorney, and the living will or health directive. Living will or health directive, they both are same. They both are named differently for ease of calling. So you can negotiate your service charges that is going to be levied by your lawyer in such a fashion that, hey, I'm going to get done all these 6 documents. When I say 6, husband 3 and wife 3. Then
I mean, will power of attorney for, POA for both. For what are the other one? What is the other one?
The health directive. The will, 2 wills for each one of us, husband and wife, 2 power of attorneys, 2 living wills. That is health directives.
What is the difference between a living health directive and a regular will?
Regular will is when you are not there.
Okay.
Living will is when you are there, but you cannot take decisions when
Oh,
you're
okay.
critically ill, dying on a bed. You can't speak, you can't write, you can't walk. At that time, even if doctors has to ask, hey, can we go and operate this person? At that time, living will dictate who has to take that decision.
Oh, okay. Got it. Okay. Yeah, I read it as power of attorney for health and power of attorney for finance. Okay. It was one and the same. Yeah.
That's all same. So
Okay.
it's just in the industry that they call it a little bit differently.
Okay.
But yeah, you are right. But I explained in a different way. But
Okay.
each
Sure.
person need to have 3 stuff being declared.
Okay. Perfect. Thank you.
Bhushan, I think your question, please.
Yeah, thank you for the information. It was really enlightening. My question is simple, like online or in-person lawyer to make this estate planner? What would be the better choice?
In person,
And why?
anytime. Because the way the online thing works, I've not done online. That's why I don't know how it works. So I have done in person with my lawyer, and what my lawyers and few other lawyers who we keep interacting. So we learned is many of the online wills have to end up as a court cases because they're not structured properly. There is no definition which needs to be required, or there is no update that they have not have done. There are many reasons, but at the end, if there is something that gets stuck because of the online versions of the drafts or online version of the wills that's been created, because online will can be purchased even from a grocery shop, to be very honest with you. So they also sell, Walmart sells the kits, but it is always beneficial to get it done from the on the paper through the lawyer, because these needs to be testified with um, um, I don't know what word that to use. If you any of you can let me know. In Kannada we call sakshi, so that there are witnesses basically who comes and signs. Yes, so that is the reason I always prefer legal will, which might be of the order of 900 to 1500. The initial cost may look a little bit high, but on the overall terms, it is better.
Okay, and thank you. I understand. I think you also answered my follow-on question about the price range. Yeah, I think I'm good. Thank you.
I think Pawan had his hand raised up.
Yeah, my question was like just an addition question to Sudhi's question. Like you mentioned, like if there is no will and husband or wife passes away, and the property is in both's name, then automatically it will roll over. Is it only the primary residence, or like if they have one investment property also, that will also be the same, or?
No, very good question, Pawan. There's something that I should have spoken, but it's nonetheless we are here to answer that. Say, for example, I'll come up with the polished version of the scenario so that everyone understands. Husband and wife. Husband passes away. It's an easy rollover or spousal rollover to the surviving spouse, and when the surviving spouse passes away, at that time, if kids are major, if they're adults, then it could be taxed in their hands. Number one. Number two scenario is husband and wife both pass away together. If kids are uh, majors and there is a will, then still the taxes has to be paid at the hands of kids. In order to mitigate this condition itself is where we always advise the parents to have at least minimum coverage of their life insurance, because what happens is many a times in Canadian scenario, in to generalize, if when kids are there to take over the possession of the property, and pay the taxes and take over the property possession, they don't have cash to deal with. Hence, if parents have been wise enough to have left a life insurance as a death benefit, it will certainly come to the beneficiaries, that is the kids. And then with that money, they can pay the taxes and then take over the position. So that's exactly how that will work. The worst case scenario in this case that you just mentioned is husband and wife, they have two young kids who are minors. Unfortunately, husband and wife passes away. Then if they don't have a will, that's a very, very muddy situation where everything goes to the estate and the process will take its own time, and kids' possession will come into question, and they will appoint the executor to do the needful, which will take time and months. So in that situation, say we have a will and there is a guardian for kids and there is an executor to take care of the proceedings, then the situation would slightly be easy. However, still the property will not be given to the minors. It will be under the name of executors until kids turn 18. Then that will be given back. But in this process, you need to pay the estate bond fees, which is taken up as an surety from the executor by the court, so that until the kids turn 18, there is a security that this money is secured. So there are a lot of things, Pawan, to be honest with you. Each case has different versions that we can go in and discuss. But yes, husband to wife or wife to husband is easy, and it will be taxed in the hands of kids. To mitigate, life insurance would solve 99% of the problems.
It's 8 o'clock. Thank you for that answer, Jawahar. It was great. And for the ones who are okay to stay, if you're okay, Jawahar, there are two more questions. If you're okay to take that, we can do that. And for the ones who want to log out, please feel free to do that. We will send out a recap email with a link for you to book appointments with Jawahar directly for a one-on-one questionnaire as well. So don't feel that you need to be there till the very end. We will take a couple more questions and log off, but we will send a recap email to everybody who's attended. Shiva, do you want to go next? And I see Amrita as well. Amrita will just take your question right after Shiva.
Sure.
Sorry, we're not hearing your voice at all. Shiva, do you want to type your question? And while he's doing that, Amrita, if you want to go ahead and answer.
Can you hear me?
Yeah, we can hear you.
Okay. So you said we need to, instead of online lawyers, it's better to go with the physical lawyer, right? So that, and you also said they need the witness. So in that case, the lawyer should be in the same city as we are, right? It cannot be from some other city because witness is required, right?
Not exactly. It doesn't have to be city-oriented or region-specific. There are many cases I've seen. People in Ottawa, they have their estate lawyers in Toronto, and they have their wills in place. So,
But like, how does the witness come into picture here?
it's about the convenience with whom that you would like to have a witness. Yeah, that is a personal arrangement that needs to be done. There is no definition of who can the witness be or who can the executor be. It's up to the person's choice.
Okay, witness doesn't matter here. Okay, witness matters, but
location
okay,
doesn't
yeah,
matter.
location doesn't matter. We can go
That's
with
correct.
anybody. Okay, got it. Yeah, thank you.
No problem.
So Shiva's question was, documents that are prepared in Canada, are they legally binding in India?
May I know in what context and reference is this being asked? is this just for the will or just for
I think
documentation of beneficiaries?
Shiva is having some audio issues. Do you want to take that up directly with Shiva? Maybe we can get him to connect with you. He also had a follow-up question saying, is there a way children can avoid taxes when they inherit? But I think we need more clarity with the questions. So maybe we can, Shiva, if that's okay, I'll share the link with you for connecting with Jawahar directly, one-on-one, and then you can have all the questions that you have. Looks like there's some audio issues, so we don't want to, guess what you're typing there. We can take that offline if that's okay.
Yep.
That's perfect. I think that brings us to the very end, Jawahar. Thank you for taking the time. We really appreciate it. It was a very engaging session. Clearly, we could see the number of hands and questions that came up. It was lovely. Thank you so much for taking the time. And I know you're going to be visiting us, and you will be here for Yugadi. I remember you saying you may have some slots available for in-person meetings as well, or you'd be okay to connect with people, on a phone call. So we will share your link with all the attendees, and we hope this very resourceful information gets passed on to everybody who's hungry for information.
Sure, Deepa. Thank you so much for that concluding remarks. Appreciate everyone's presence. And I just try to share my knowledge and day-to-day dealings or works that I do. Apart from that, every one of you will receive the resources as I promised, number one. Number two, in addition to that, you'll also receive the booking link for if you're interested to schedule a time with me online or in person, as Deepa mentioned. And also I'll share my WhatsApp group link so that you can join and then learn your personal finances on weekly basis. So these are the three things at least you can expect from my side in next couple of days or tomorrow. Of course, I'll abide by the way it is to be done from the community members. So we'll go through that channel to get that things passed on. Thank you.
Thank you.
I would like to take a moment to say thank you to Jawahar. Yaradru personal experience, I'm not talking as part of committee, but personally, we have good experience with Jawahar. So if you want any experience questions or something reference, you can reach out to us. Yeah, I definitely assure you that he's well knowledgeable person. You will see the difference. Thank you.
I too echo that, Kausalya. Thank you.
Thank you.
And my experience has been good as well, very good actually, in fact, with him. So I would encourage everybody to connect. And somebody posted a question, how much is he going to charge? And I asked the same exact question when I consulted with him, and he said he's going to charge very heavily, maybe a cup of a coffee or a tea. I guess this is going to be the same way. So just wanted to let you guys know.
It's just matter of time, Bhushan. Once I have my certifications of CFP, then I am legally bound to charge my clients for my consultation. Until then, I am free.
Okay, I hope you get that certification soon, but still, able to consider our community for free consultation over a coffee. Let's see. Yeah. Until then, so guys should hurry up then to consult with you. All right. All the best.
Thank you, Bhushan. Thank you. I see one hand up. Ramya has raised.
We can take that if you're okay with it.
Yeah, I'm here for next couple of. I have prepared to be there until 8:30, so I'm okay.
Can you hear me?
Yes, Ramya, please go ahead.
We kind of like most of us have like assets back in India and here as well. So do you think like it's better to have two different bills, like one for here and one for back in India?
To be honest, this is more of an estate lawyer question. But as far as I know, since there is a treaty between India and Canada for there is no double taxation, and if you have a will here, I may be completely wrong, Ramya, don't quote me on this. We need to
That's
clearly
okay.
understand
Yeah.
from the lawyer. But it should be absolutely fine if you have listed all the details of what happens to your properties in the Canadian setup of will, so that because you are Canada's citizen, right?
Yeah.
You are probably an OCI in India.
Yeah.
Yes, there is no harm in having two, but one will probably should execute with different executors. Just my point would be some of the executors for Indian properties needs to be separated out,
Yeah.
and the executors for the Canadian stuff to be separated out. Thereby, you're not clubbing that portion, which if you keep that separate, I believe one will should uphold. But uh, in terms of the will itself, I'm not sure whether it is a mandatory to have a separate will or one should do. In my personal opinion, one should do, but we need to check.
Okay. Thank you.
Sorry, I may not have been an help on that.
Oh, that's fine. Like just introduction, like
Yeah.
how to move about things.
But it's always better to keep that in mind to execute that side of the will, because many times we live here, we don't know what's happening on that side, so we need to be
Exactly.
very careful. Yeah.
Yeah. Thank you.
Jawahar, looks like Shiva's audio issue
Yeah.
has now been resolved.
Yes.
So he's been waiting
Can you
patiently. So if we can take that one question, that would be great.
Yeah, yeah, absolutely.
can you hear me, Deepa and Jawahar?
Yeah, we can hear
Yes.
you.
Oh, that's super. So yeah, so maybe you answer this question, but like the documents that we prepare as part of the estate planning, right? Like be it will, be it power of attorney, or be it all other documents that you said, are they legally binding in India, or do we have to follow some procedure, maybe adjudication in India or something, to make it legally binding, or we have to have two separate estate plannings, one for India, one for Canada?
Uh, from the property execution standpoint, in terms of assets, Shiva, as my stand or answer response would remain same what I gave to Ramya. I'm truly not sure about whether you need to have a separate will, but one thing that I can certainly say is from the health directive perspective or the power of attorney perspective, the
Okay.
person that who you name, they can live in India, or it can be that person. So consider a scenario where in your case, I am turning every question to a scenario because
Yeah, yeah.
it helps to understand it easy, right? So
Sure.
you live here, you have an home, you're a Canadian citizen. If something were to happen, touch wood, when you're traveling to India, I think the health directive would still be in place to take the decisions. And
Okay.
these days, as I earlier said in the session, that lawyers are aware because it's become so global, where the paternal side, the maternal side, and your family, all three living in different countries. That's happening today, right? So
Yeah. Yeah.
absolutely, that's there. Only thing is, lawyers who you work with needs to be smart enough to draft that in a way to keep it in generic sense. Like instead of saying that, hey, if Mr. X uh, goes through this particular health condition where he is not able to speak in Canada, rather lawyers will say anywhere in the world, this person would be responsible to take his health decisions. You
Yeah.
understand what I see?
Yeah. Yeah. My question is that the document, the power of attorney. So if I'm making a power of attorney in India, it is not legally valid if it's not registered with a sub registrar. So the one that the power of attorney, the document that I prepare here, maybe for the legal
Yes.
survival, you said
Yeah.
living will or something.
Living.
So
Yeah.
so when I travel to India and then something happens, then will the document, the living will that is prepared here, has any value there in India, or that document needs to go to some process to make it legalized there? Is that was my question.
From Canadian standpoint and personal opinion, it should be sufficient because we travel a lot. So those
Okay.
things cannot be country specific, to be honest.
Okay.
But from India perspective, what is India's structure of it may not be called as a living will, it may not be a power of attorney. Power of attorney is there, but
Yeah.
will is there, but I'm not sure about the living. So we need to understand that side of the legal structure
Okay.
to see if it is valid or not. So from Canada side, yes, I feel this should suffice the global events if it has to happen.
Okay, okay. So my third question, a generic question, like, see, I can name my wife as beneficiary, and then I can name my kid as my beneficiary. Like, can we name a chain of beneficiaries? Like, something happens to this guy, that guy, and everyone. Like, what happens finally?
Uh, I'm very glad that you asked this question because there are different types of beneficiaries when we put up our life insurance or investment products. I'll take up the example of life insurance. Under life insurance, we have immediate beneficiaries, we have contingent beneficiaries, and we have trustees. I'll take a moment to explain these three because it might be of interest to everyone, or and especially to you since you asked the question. Thanks for that. So the immediate beneficiary will get the proceedings as a death benefit in case of life insurance if something got to happen. And if the beneficiary also is living, then that's fine. Say, for example, the insured person and the living and the immediate beneficiary passes away together. Okay,
Yeah, yeah.
then the contingent beneficiary comes into picture, where the death benefit proceedings will go to the contingent beneficiary.
Okay.
The contingent beneficiary can be your blood relative, your brother, sister, friend, whoever you believe will do the justice in your absence. Number one. But the only requirement I always tell my clients whenever they write life insurances with me is the contingent beneficiary whom we are naming, apart from your spouse or immediate kids. Mostly they are in India. Their names on their IDs should match their bank account name.
Okay. Okay.
Reason, many cases where we know from our industry practice, we hear they name the contingent beneficiary in the policy here, but their government issued ID back in India may have a different name.
Then
Canadian,
there should. Yeah.
yeah, there is a lot of confusions. Canadian law doesn't take it easy to
Okay.
expand the middle names, long names. So yeah, that simple exercise will really help out to ease things when you
Okay.
name contingent beneficiary. But I'll also tell you when beneficiaries or contingent beneficiaries are minors from your life insurance policy, then the trustees come.
Mm-hmm.
Within the life insurance policy, there will be a field to add trustees. So trustees are nothing but those people who will handle the death benefit proceedings on behalf of the minors until they reach an age to become majors.
Mm-hmm.
Yeah.
Mm-hmm.
Again, the same phenomenon. Trustees needs to be properly named, their IDs to be matched, so that there is no legal hassles.
So does it end with contingent beneficiary, or is there a contingent beneficiary?
There is no layers to this that ends, but there are different percentages that one can assign to.
Okay, so my scenario is like this, right? Like when we are sorry, when we are speaking life insurance, we obviously decide we are obviously are speaking of what happens to us, what happens to the things after us, right? So say I name my wife and the as the beneficiary and contingent as my kid, and with you all going somewhere and something happens, so then like that's where my point was, contingent. So is there any guidance for that?
Yeah, we can do that as that's a well thought through question. And not many a times people think to that deep level, but there is a provision to name contingent, alternate contingent also.
Oh, okay, yeah, sure, yeah.
There is a provision, but they'll also be called as contingent. There is no other name to it. That's all.
Oh, okay, sure. Because like we hear people traveling, like all families travel together, and we hear, especially because in COVID times, entire family wiped out, and like yeah, so those things.
No,
And
no,
my
valid
last
question. Yeah.
yeah, my last question is that you mentioned there is some tax burden on the kids in case like if for the residents, right? If both of the house spouses are not there and child inherits that, and there is a taxation for that, is there a way to avoid it?
The best way to avoid, not from the legal standpoint, there is, see, one thing, Shiva, here at any stage, be it RRSP, be it your residence, CRA wants a cut. Uh, Somewhere or the other, they will ensure to take the money. That cut point you cannot change. Only thing that you can do is smart enough to plan your, estate in such a way that you can prepare your kids get a death benefit which they can use for paying towards the taxes and retain some portion of it for their life.
Okay, okay,
That's
okay.
the only way and the best and efficient way to do it.
Okay. Sure. Thanks, Jawahar. Thank you so much for patiently listening to my question and answering patiently. Thank you so much.
No problem, Shiva. My pleasure.
Thank you. I think that was a good question. I'm sure it answered a lot of questions for other people who were thinking of it. But thanks for asking. And thank you, Jawahar, for staying a little longer and answering all the questions. We will be sharing the recordings with the ones who attended. Is that okay with you?
Yeah, absolutely. That's fine. And as I promised, I'll share certain things with you and resources directly, those who have given me the email ID, so that you can circulate to all those members who had registered it. I understand they may not have had a chance or a bad day or some situation in life that they couldn't attend. It's absolutely okay because I'm not going anywhere and I'm going to come very soon. So we can meet and talk. No worries.
That sounds great. Thank you so much, Jawahar. Have a wonderful rest of your day. Thank you, everybody, for joining.
Thank you so much, everyone.
Thank you to the team for helping with this the topic. This has been a very long-waited topic for the community members I speak about. So thanks so much for arranging this, and thank you, Jawahar, for the information.
My pleasure, sir.
Thank you. Bye.